Members, we have a quorum. Let's call to order this meeting. The first part is meeting with deputations and with the administration. Let me invite the administration to come in. Just let me read out from the attendance list. We're joined by Ms. Bernadette Lin, Secretary for Development, Ms. Doris Ho, Permanent Secretary for Development, and also Ms. Joyce Tam, Land Registrar, Mrs. Alina Chan, Deputy Secretary for Development, Ms. Zhang Hoi-san, Principal Assistant Secretary, and also from the Land Registry, Mr. Eric Lee, Deputy Principal Solicitor, and 3 representatives from the Department of Justice, Ms. Francois Lam, Mr. Anderson Chan, and Ms. Eunice Wong. Let me also invite the deputations to take a seat. We're going to meet with deputations today. They will speak on the relevant bill. We have 8 deputations, individuals sign up. So I will first invite them to speak, and then the administration can give a response. Members can also put questions to them. In relation to all the submissions received and the views expressed by deputations at the meeting, I will invite the administration to give a detailed written response after the meeting. I see that we have everybody here. Let me welcome the administration and deputations individuals to our meeting. A number of points to note, please. If you need to use simultaneous interpretation service, please put on the earpiece. Channel 0 is floor, Channel 1 Cantonese, Channel 2 English, and Channel 3 Putonghua. Each can speak up to 4 minutes. We have a timer in this room. It will go off when 4 minutes are up to remind you that your speaking time is over. And please also note that the views and submissions made are not covered by the Electoral Powers and Privileges Ordinance. Please also note the matters to note from members of the public attending meetings in the public gallery or in conference rooms of the Legislative Council. A copy of this notice is now before you. Please observe the rules set out. You must observe the order of the meeting. You must not shout or show any slogans. And if you have prepared speaking notes, please put down your name and hand the notes over to the staff members before you leave the room for our consideration. So let me invite deputations to speak now. Let's start with Mr. Zhang Shuifeng. Ms. Zhang Shuifeng. Chair, members, good morning. On behalf of the Law Society of Hong Kong, I'd like to help the Legislative Council and the public understand the viewpoints of the Law Society of Hong Kong as well as the new land approach. First of all, the Law Society of Hong Kong is supportive of the introduction of the land title registration system. It provides certainty to land titles. It also streamlines the assignment procedures so as to create a more favorable environment for businesses in Hong Kong. The new system will also streamline the due diligence procedures in conveyancing process. In the future, lawyers will no longer need to go through 15 years of historical deeds, and this can help save time, and this can also address the inconvenience that may be brought about by the relevant deeds or documentations being lost. In order to ensure reliability and effectiveness of the new system, the applicant must submit the application with a certificate issued by the solicitors, and this will impose a lot of responsibilities on lawyers because of the indefeasible title thresholds. The lawyers will still need to be very careful in ensuring that the property comes with good title. Now, in Hong Kong, property frauds are prevalent. Lawyers are concerned whether the new system will spark a surge in the number of fraud cases, especially under the principle of indefeasible title. For an innocent buyer who purchases a property for value consideration, they will continue to enjoy indefeasible title, whereas the innocent buyer can only receive indemnity from the indemnity fund instead of recovering the property. Now, the costs of fraud are very high under the existing system, and it's quite difficult to perpetrate a crime. But in the new system, as long as the fraudster steals or forges the identity card of the property owner, it will be easy to submit relevant documents so as to commit fraud. And in light of this, we have talked to the land registry on verification of title. And we've also promulgated a set of guidelines comprising some 20-odd pages and 49 paragraphs so as to minimize the chance of fraud as much as possible. In terms of the indemnity fund, regardless of the value of property, regardless of the number of units, etc., the cap will be imposed, and that is a cap of $50 million. After Gazetted on the 28th of February, the Law Society was consulted. We also have a number of questions to be clarified, and we hope that these matters can be addressed so as to reduce errors in the process and reduce the number of disputes. Basically, the Land Titles Indemnity Fund is supported by public money, and when there are more claims, inevitably, the government will need to impose higher levy rates. So, I'm sorry, your time is up. Next, Mr. Gan Ginhang. Thank you, Chairman, members. On behalf of the Consumer Council, I'd like to express our views. First of all, the Consumer Council is supportive of the land title registration in Hong Kong in place of the deeds registration system. We believe this will provide clarity to land ownership and land title. It will also streamline the conveyancing procedures. That means cutting costs and saving time. At the same time, we are aware of the challenges in terms of some technicalities and transitional arrangements. So we support the new land first approach proposed in the bill. We believe that the experience accumulated under the new land first proposal will help us transition fully to the land title registration mechanism. At the same time, the land registry should be given sufficient resources so as to engage other parties such as the estate agents authority, etc., to complete the infrastructure robustly and leverage on technology for smooth implementation of the system. The Consumer Council also urges the government to work closely with stakeholders so as to promote the new system. Next, Ms. Leung Dat Lai.
I represent the Estate Agents Authority. The Estate Agents Authority supports the implementation of the title registration system on newly granted land first, with a view to securing an early start of the title registration in Hong Kong, which would in turn enable industry stakeholders and the public to enjoy the benefits of the new system earlier. It is understood that if the bill is passed by the LegCo, the government will formulate and introduce 6 pieces of subsidiary legislation into the LegCo for negative vetting in 2026, with a view to implementing the enacted legislation in the first half of 2027. As the bill is complex and the subsidiary legislation will likely touch upon operational issues under the new system, such as requirements on instruments to be lodged for registration, supporting documents for applications and registration procedures, etc. The Estate Agents Authority suggests that sufficient time be provided after the passage of the bill and the subsidiary legislation, but before their actual implementation, for the government to educate the public to understand how the new laws may affect their land interests and relevant bodies, such as the Estate Agents Authority, to consider the practical issues and implications of the new system on the practice and operation of their licensees or regulatees, and whether appropriate guidelines, such as practice circular and guidance for their respective trade, should be issued. The Estate Agents Authority understands that the Land Registry intends to prepare practice guides and provide professional training programs tailored for different sectors of industry practitioners to prepare them for the changes to be brought by the title registration system. The Estate Agents Authority welcomes such efforts and would like to emphasize that the guides and training for estate agents should address the trade's needs and should be coached in easily understood formats, so that the estate agents can explain the new requirements to their clients in simple terms and give appropriate advice if needed. The Estate Agents Authority will continue to monitor the legislative process of the bill and its subsidiary legislation and liaise with the Land Registry on the implementation details of the new title registration system, with the aim of helping the estate agency sector to better prepare for the new system. Thank you.
下一位林家輝先。
Next, Mr. Lam Ka-fai. Thank you, Chairman. I speak on behalf of the Hong Kong Institute of Surveyors. We are in strong support of the bill, and we fully hope that this bill can be applied to property transactions under the new Land First approach, and that landowners, buyers and sellers alike will be able to enjoy greater title certainty. Now, this is of utmost importance. However, I wish to raise one point. In the UK, the title registration system has been in place for a rather long time, and yet there are problems with old titles. Now, the situation is similar to Hong Kong. Now, in the UK, apart from title registration system, they also have a title plan and also a legal charge. They will also publish the legal charge, in other words. It is very important for this information to be provided because it affects the title, and there are also other matters affecting good titles, such as easement rights, restrictive covenants, etc. There is also the right of light, and that means the lighting must not be shaded in whatever ways. And I've come across some of these cases. I hope that the administration would consider these supporting measures after introducing the title registration system. Thank you. Next, Mr. Lau Chi Kwong. I'm chair of a working group of the Hong Kong Institute of Surveyor. My profession is one of surveying. I fully support the bill because it provides clarity to land title. I'm not going to repeat the points made by the former president of the Institute, but I do note in our line of work that there are many landowners in the new territories facing problems because of legacy issues. There is a problem with unclear demarcation of their lots. Our sector recommends putting in place title plans. Surveying should be done to verify the demarcations and boundaries. This can be a one-off exercise to clear the ambiguities and address legacy issues.
All right, next, Mr. Wang Yuzhou. I'm a land surveyor. I'm in support of the Registration of Titles and Land Miscellaneous Amendments Bill 2025. I'd like to express my views. for land registration system is about the assignment of titles. And people refer to the lease plan and the assignment plan. In case of any inconsistency, landlords need to seek professionals to help them to draw the land boundary for verification and checking. Say, in relation to the transfer of a vehicle, a large cloth is used to cover the vehicle. Buyers don't actually know what cars they're going to buy. This situation is particularly serious in the new territories. 120 years ago, there used to be some agricultural land approved by the administration. The minimum size is 436.5 square feet. Land prices are very expensive in Hong Kong. It is quite outdated to use this figure as a reference. Regarding my suggestions, I suggest in each land transaction, a land boundary sketch should be provided. It needs to be provided by a qualified land surveyor under Cap 473. In case of any dispute, there could be a tribunal of land boundaries. The government could set up this tribunal to make any determination or decision. The benefit is that the process can be expedited in order to resolve issues in relation to land boundaries. On the other hand, we can expedite the time taken to acquire land or to resume land. This is especially true when we take into account the Northern Metropolis and Santine Technopole. And relevant information should be provided, and it should carry binding effect. Thank you. Next, Mr. Kwong Wai Yin. I'm speaking on behalf of a property consultant company in Hong Kong. We support the bill. This has an impact on property developers when they acquired land. It takes a long time to go through all the procedures. Some documents may go missing. After the introduction of this bill, the efficiency of property conveyancing will be improved, and I have 4 main points to express. Applying for rectification and indemnity are very important measures under the existing mechanism, but there is a lack of experience in the market. In relation to application procedures, the government should offer more explanations in subsidiary legislation. Any standard in the market, appeal mechanism, evaluation by professionals, the time taken to get the fund, and detailed arrangements on the interest and so on. The public should have access to properties. On the 8th of April, there is a document by the Legislative Council. When it comes to professional services and valuation of property, we oftentimes need to refer to historical data and documents in the past. If this is made possible, then it will help. We also need to optimize the land registry system. We want to improve the reliability of data as well as the security of the data. This will enhance public confidence. I understand the New Land First proposal is a practical method. the administration should study the implementation of the proposal so that it will be extended to cover different pieces of land. The government should pilot the measure in pieces of land where the history is not that complicated. Next, Mr. Ouyang Jihong. Thank you. I speak on behalf of the industry. I speak from the perspective of developers. I work with agricultural land and I'm involved in different land transactions. This streamlined system is worth our support from the perspective of users, of course, and I'd like to share my views. For agricultural land, we purchase lawyers know it's actually very difficult for the land to have 15 years. At the time of property transaction, when the title or the position doesn't tally with the other on the document, there is a title defect. And that happened in a transaction of remortgage. As a user, I witnessed a lot of such cases. We support the administration's proposal. This bill streamlines a lot of procedures so the public will have peace of mind. Say, oftentimes there are title defects when a property is mortgaged and afterwards is remortgaged through another bank. So I support this bill. All right, thank you. I'll now give the floor to the administration to respond to deputations and views in brief. Members who would like to speak, please press the button to request to speak. I now give the floor to the Secretary. Thank you, Chairman. I thank all the individuals who attend the meeting today. And you are exactly the stakeholders from the legal sector, from the consumer council, from the real estate sector, as well as from banks and professional groups. There is also a representative from developers. We've heard you all. And I'm glad to see a consensus that we have your support. In our implementation of the title registration system, we'll first try the New Land First proposal. There are a lot of implementation arrangements to be confirmed. We heard you very clearly. We will flesh out the implementation arrangements or details. All of you find it a good start. What about the steps in the future? We've heard your views. That is on implementation and on future arrangements. How can we take it further in the future? Let me first focus on our future plans. Title registration is good. We know this. So when we implement the New Land First proposal, we should move on to the next stage as soon as possible. At the last meeting of the Bills Committee, we already said that the land registry is conducting some analyses, and we will give an account of our analyses to the Bills Committee or the Council later on. We've heard the views in relation to the next stage. Will we focus on recent land lease cases? These are less complicated, and I find it quite appropriate. But in relation to the timeline, it will hinge on the analysis being conducted by the Land Registry. We will adopt a pragmatic approach, but we won't drag our feet. Next year, we will give an account to the Council. Just now, deputations mentioned implementation. Ms. Chung mentioned a burden on lawyers. It seems the administration mainly protects the new buyer, so the former owner of the property. Will there be a burden on lawyers when the lawyer is involved in the property transaction? Just now, stakeholders have expressed their views. This is an important step. This helps streamline the procedures or the system. This is without doubt true. Therefore, for property transactions in the future, it's more efficient and the business environment will improve as well. There will also be more protection for property owners. They have peace of mind. These are the pluses of the system. But after all, this is a new mode, a new system. It's of course good not to have to check the historical data in the past decade or so. Just now I heard from Ms. Chung, and I had a better understanding of your situation. Now that the system is streamlined, will it give rise to even more fraud, given the fact that it's less complicated comparing with the past? Well, I don't think we need to be worried about this. When the system is streamlined, we may focus on working on anti-forgery features. And we will inform the property owners unless we cannot get a hold of the property owners. When there are anti-forgery features, is actually easier for us to verify with the Land Registry. As long as you exercise due diligence and as long as you act in good faith, I believe law protects you all. In relation to the operational mode in the future, I understand it's a little bit different from the system that has been in place for decades. We will provide Q&A and guidelines. I agree, the more detailed, the better. We will liaise with the banking sector, lawyers, and the real estate authority or the estate agents authority. The more practical, the more detailed, the guidelines and the code of practice will be better. After all, in the event of fraud, no matter what the system is, be it title registration system or deeds registration system, there will be people who want to break the law and exploit the loophole. Based on the information given by the police force, such cases are few and far between. In the past 5 years, about 10 cases or so. These are cases involving the fraud in relation to property transactions. With the new system in place, I believe we can intercept more of such cases. We'll be in a better position to combat such cases, but of course, one such case is all too many. so we will fare better in relation to legislation and rules.
權第一
A number of deputations share the same perspective, and that is there would be greater clarity in terms of title of properties, but then there would still be ambiguities regarding land boundaries. Be it the deed registration system that we're practicing or the title registration system to be introduced, there will still be ambiguities about boundaries. A prospective property owner may wish to take forward the development, but because of ambiguities in land boundaries, there may be some hiccups and no conveyancing is involved. This is a pain point. And that is why we must take the first step of a title registration system so as not to delay the matter further. Now, we have proposed to introduce the title registration system for new land under the New Land First proposal. When it comes to new land, land exchange may also be involved. In that sense, new land leases will have to be signed. So be it a private treaty grant or a land exchange with the government, the land boundary map verified, the lands verified by the Lands Department will be published. So in relation to new land, we don't envisage a major problem. For existing land, however, it may be different. Regardless of the system, the problems may still remain. I understand the concerns that for new territories land, the land boundary issues should be clarified as quickly as possible. I also note that there are calls for the government to intervene so as not to cause any delay to private development. Now, this is something that I can bring back to the Lands Department for consideration. I just want to emphasize that these issues are not necessarily tied to the proposed system, and there is no need to further complicate matters. I fully appreciate that we're talking about the land parcels in the new territories under the old Crown leases, and we'll be happy to further explore these issues on other occasions. To address another point raised just now, we will be enacting several pieces of subsidiary legislation in due course. Our plan is to wait for the principal legislation to be passed first, and then there will be time for us to complete the enactment of subsidiary legislation next year, and the bill will only come into effect in the first half of 2027. So that means there will still be slightly more than 1 year for us to fully work with the stakeholders and draw up the subsidiary legislation. I urge stakeholders to work with the government to complete this exercise. Perhaps I'll pause here. I'll see if there are any follow-up questions from the floor. Thank you, Secretary. That's a very clear and detailed reply. I open the floor for members to ask questions. Ms. Doreen Kong, Deputy Chair Louis Long, Andrew Lam, Tony Chair, Jimmy Ng, Ambrose Lam, and myself. Deputy Chair, Ms. Doreen Kong, question and answer, 4 minutes. Thank you, Chairman. Thank you, deputations, for coming here and offering us your invaluable views. I have 2 questions. The first one is from Ms. Lillian Chang from Law Society of Hong Kong. At the last meeting, this point was raised by a number of members. That is, whether the government can introduce the title registration system for old and existing land, and that it could be introduced in one go. I'd like to have the take of Law Society on the matter. Now, the second point is this. The Secretary mentioned a number of subsidiary legislation items. So my question for the Secretary is this. In drawing up the subsidiary legislation, there will be time to consult the relevant professional bodies. How much time are we talking about? Because as I understand, the Law Society spent a lot of time in examining this bill. So we value their opinion. I just want to know what time frame you refer to so as to ensure that there will be sufficient time for their consideration. Ms. Chang? Under the New Land First proposal, the system will first be introduced for new land first before extending to existing land. We are in full support of this approach because we don't envisage a lot of cases under the new land approach, and this will provide a period of buffer so that if any error in the system is identified, the administration could put forward legislative amendments to improve the system and avoid major land disputes. Land development and investment present a very essential part of Hong Kong's economy. We must ensure stability so as not to deter investors. So I fully support the New Land First approach. The land system in Hong Kong has been in place for many years, and we must not overlook the difficulties. We must be cautious. Ms. Kong, any further questions? Right, about the time frame, may I ask the Secretary to elucidate? I will invite the Director to take this question, or the Registrar to take this question. That is, when the items of subsidiary legislation will be tabled into the Council for negative vetting. And then in terms of time frame, perhaps you'll also explain the time reserved for consulting stakeholders. Registrar. Now, according to the timetable, if the bill is passed within this year, items of subsidiary legislation will be tabled in the Council for negative vetting next year, and we are looking at the third quarter of next year at the moment. For particular pieces of subsidiary legislation that the practitioners or the law societies may be more concerned about, and namely the subsidiary legislation that already exists under the current deed registration system, I believe that more time will be needed because of the potential impact and implications. So I'm thinking about the first or the second quarter next year. Even if the draft is not ready, I hope by then we'll be able to consult the Law Society on at least the concept of the proposed legislation. Mr. Louis Long. Thank you, Chairman. First of all, I thank the deputations for providing their valuable input and their perspectives on the bill. This can surely help the Bills Committee in considering this bill and considering the different perspectives. In the interest of time, just now Ms. Lillian Chang from Law Society didn't seem to have complete her whole speech. So let's see if Ms. Chang would like to continue, because I'll be happy to give the floor to her now. We'll be interested to find out the latter half of the second half of the speech. Thank you. Well, in fact, I already answered the member's question just now relating to the New Land First proposal. We are in full support of that, and I believe I already explained the reasons. Right, I just wanted to hear the whole story, that's all. Next, Mr. Andrew Lam. Thank you, Chairman. I thank everybody for coming to this meeting. I have 2 questions. Now, first, according to quite a number of deputations, they welcome the New Land First proposal. Mr. Joseph Wong, in particular, referred to land boundary issues. So my question specifically is this. In your experience, if we are to take forward the New Land First proposal, is it that these conflicts regarding land boundaries will be resolved, or will there be outstanding issues that we should pay attention to? The second point relates to Law Society's viewpoints. After the streamlining of conveyancing procedures, it may be easier to forge documents, but the Secretary also categorically explained the anti-forgery features, and I'm happy to learn that you have some 40 recommendations. Do share with us. Among the 40 you mentioned, is there anything that can help minimize the forgery of documents and also prevent fraud? Can you share with us specifically what more can be done to help refine the gatekeeping job? Right, I think the second question is very clear. It's a question for Law Society. What about the first question? Who should take this question, Mr. Joseph Wong or Mr. Francis Lam? So I will give the floor to Law Society and then Mr. Wong. Well, coming back just from another country, I am sorry, I have an ear block due to a nasal sinus issue. So I didn't catch it very clearly. I'm afraid I didn't catch what was spoken softly just now. Would the member please repeat the question? Well, I will use my normal voice. That is, I heard your concerns about forgery, and I also heard the Secretary explain the administration's efforts in introducing anti-forgery features. I understand the Law Society is going to put forward 40 plus recommendations. I want to know whether among them there'll be anything about prevention of forgery and fraud. If not, then please consider including these as well. The answer is in the affirmative. In fact, we have put forward the recommendation, and this has been accepted by the Land Registry, and that a land title certificate must be submitted along with the application. Of course, the certificate is in no way a certificate of land title. It is not a certificate to prove ownership of title, but it poses an extra hurdle for fraudsters to perpetrate that crime. And we also would like to remind lawyers in the future, the seller of the property will need to prove good title and that he is in the capacity of selling the property. Now, so there are anti-forgery features and fraud prevention recommendations among the 49 recommendations we've made. And in fact, we've proposed these fraud prevention and anti-forgery features to be included in the bill. Now, our concern is this. If you are director of the company in possession of a property, the fraudster will be able to submit an application for change of directorship of the company to the company's registry in order to commit fraud. There is no way to discover the false identity. Now, of course, in the future, the land registry will issue SMS to owners, but frankly, not everybody checks the SMS. And we also have buyers who are old and frail, who live overseas, who they may not notice the phone message. And as a result, the property is sold by the fraudster, and the only avenue of redress is to apply for compensation.
稍後
Well, the submission of the Law Society of Hong Kong will be submitted to the Secretariat afterwards. Well, Miss Andrew Lam was speaking quite gently, so I'll give the floor to the other deputation to tell us more about the land boundary. Regarding the new Land First proposal that will solve the issue in relation to land boundaries, whether new land ground or in situ, there will also be clear land boundaries in the land lease, so I believe this issue won't be around anymore. Thank you. Next, Mr. Tony Tse. Thank you, Chairman. First of all, I thank the deputations and the individuals for coming to the meeting to share their views. We've heard views from different professionals. I hope the Law Society of Hong Kong will provide their written submissions to us as soon as possible. That will allow the Bills Committee to study their proposals or their views. In relation to land boundaries, about 2 decades ago, the surveyor sector was concerned about this, and this no longer happens to newly granted land. I thank the Secretary. We do need to look into the situation as soon as possible. We need to solve this problem despite the fact that it's complicated. We now go with the low-hanging fruit first. Afterwards, we'll move on to deal with the more complicated bits. I'm glad to see that most members are supportive of this. It's very important to start with the first step. Just now, Collier asked about a question that is under the new regime. For the newly granted land, about the information of property or assignment in transactions in the past, do we still allow access by the public to such record? I'd like to hear from the administration. Thank you. I'll give the floor to Ms. Joyce Tam, Land Registrar, to take Mr. Tony Tse's question regarding the checking of the title registration record under the new system. This will only affect the property entries, as this is conclusive evidence. Documents returned will be deleted. There are application forms as well as other documents. For deleted entries and documents, they will be defined as historical data. Under the existing ordinance, the public has access to the land register. Likewise, the public has access to title registration system as well. including existing title as well as the record in the past. Application forms and supporting documents contain personal particulars such as name, Hong Kong ID number, and so on. In order to protect privacy, we will review such requests on a case-by-case basis. As under the new system, we don't need to, the public doesn't have to inspect the record. And the public will have access to current documents in relation to historical data. We will allow persons authorized under subsidiary legislation to inspect such data, say lawyers, financial institutions, authorized persons, property agents, and so on. This is to strike a balance between the needs and the protection of privacy. Simply put, for one to check the land register, the public can do so. However, in relation to historical data, that is not in relation to checking the title of properties, only professionals have access to such record. I'll give the floor to the Secretary, and then Mr. Tony Tai can follow up. Well, this meeting have live broadcasts. Let me make it easier to understand by the public. When the title registration system is in place, people have access to title history. However, when the new system is in place, can one check all the historical data in the past, say the number of assignments or transactions, the amount involved, any encumbrance? The public can still access such information in the future. What the land registrar mentioned is when a mortgage has been paid off, you will still see the record of a mortgage. However, for historical papers or documents, as they contain a lot of personal particulars, they won't be made available to the public. In relation to the amount of money spent on acquiring the property, such information is still available to the public. In relation to a property transaction agreement, such documents can only be accessed by professionals. In other words, for basic information, the public can still access such basic information. Mr. Tony Tai, I thank the Secretary for the very clear explanation given by the Secretary. The government provides such services on a needs basis. And I don't want to see additional burden on the manpower or the resources of the Bureau. We may go digital. Alright, the administration may take note of it. Next, Mr. Jimmy Ng. Thank you, Chairman. I thank all deputations for your valuable views. Under the new system, just now, Land Registrar said the professionals will have access to all historical data, and I'd like to know under what circumstances professionals can access such historical data. There may be a lot of possibilities. Say when I'm involved in a transaction of a buyer, then I will have access to such historical data. If I'm representing a litigant in a legal proceeding, whether resulting trust or constructive trust, And if I cannot identify that person to be the one who deceived me 3 decades ago, I won't be able to furnish any evidence to the court to prove such. So under what circumstances may such professionals, such as lawyers or banks, access such record in the past? If someone comes to report loss of the title certificate, I'm not sure about the Chinese name of a title certificate, but anyway, how will one be allowed to get a new title certificate? And in the new title certificate, will you see record of renewal, like home visit permits? Say the number of times when one applies for a new title certificate again. Say, if I can tell that a title certificate doesn't print with the figures 01, then someone may delay in handling such applications. Land Registrar. Well, what you mentioned just now is covered according to our plan. The professionals coming to make such an application will have to provide us with the purpose. In other words, before legal proceedings begin, I already need access to such information. So will I still be allowed? Yes. Title certificates are close to our heart as well. If one loses his or her title certificate, how can one apply for a new one? When one applies for a replacement, it is no different from an application. One needs lawyers to conduct verification, inspections. Lawyers will have to carry out inspections. Well, lawyers won't be able to do so. Someone has already lost 01. Shouldn't the Immigration Department be responsible for it? Well, you may let the land registrar speak first. Well, we need to verify whether that person is the real owner of the property. We will see whether that person can provide the identification documents. And that person will be required to make a statutory declaration. One will have to take out advertisement on the newspaper or make a declaration in the newspapers. When we're satisfied one has really lost his or her title certificate and has to ask for a replacement, there will be numbers 01, 02, 03 to show the number of replacements. There will also be an online verification system. In other words, on the title certificate, there will be NFC label as well as a QR code. When you scan such codes on a mobile phone, you will have access to information so that you will know whether that title certificate is the latest one issued by us. You will be able to tell. Lawyers can check such title certificates. When you have the replacement certificate, you can check. Thank you.
Mr. Ambrose Lam, I thank the Law Society and other deputations for coming to our meeting today. I also thank the administration for taking on board our suggestions in relation to removing the provision regarding criminalizing the work of the professional if fraud is involved. Well, fraud is quite prevalent in Hong Kong and it's really difficult to address. I'm concerned about the seed money for the land titles indemnity fund. It's such a small amount. I wonder if this is sustainable, because once fraud has been committed, $12 million may be involved. So if the amount is so small, my question is whether this fund will be kept afloat in the long run. The second question is, when you check the title in the register, the most important point is to verify the identity of the owner. I don't think it matters whether this is a true, the original or a copy. Secretary. Indeed, after introducing the title registration system, what matters is what is set out in the register. In other words, we'll rely on the title registered. And in that sense, in fact, there is no need to issue a title certificate. But as mentioned by the Law Society representative just now, we want to be able to help the legal professionals to verify the identity of the owner, because this has always been the practice. They want something on paper to verify the ownership, and that is why we have introduced this system of a title certificate. Merely losing this certificate will not cause a loss of your title, because it's just a certificate representing the fact. The other point raised by Mr. Lam is whether we have sufficient amount in the balance of the land titles indemnity fund. In fact, as mentioned in the paper, we have a standby loan facility subject to a cap. Should there be insufficient balance, we can provide buffer. However, in the first few years of its operation, we don't envisage insufficient fund balance. When I think the registrar can perhaps share with members the process of analysis. In 2022, we conducted an assessment on the indemnity fund. We have had regard to the number of fraud cases and the relevant data, such as the number of cases, the amounts of losses incurred, etc., in the past 20 years. The consultant, as a result, analyzed the data and recommended a levy rate, as well as the starting size of the fund. According to the consultant's assessment, for the assessment period of 20 years, the fund should stay afloat. In terms of the consultant's assessment on fraud, as I just read from the report, according to the historical data, there weren't many fraud cases. In fact, the consultant even proposed raising this number in his analysis. Despite not having a large number of fraud cases in the past, the number used in the analytical model was raised. That means the consultant also included cases not yet reported and therefore not kept in the database. The consultant also considered whether the fund could pay out compensations for consecutive years if fraud cases become rampant. And that means the consultant conducted a sensitivity test and also adopted a larger number of fraud cases in the projection. And the fund will still remain self-sufficient. In fact, we've also included the latest figures in 2024. Members may have noticed less property transactions. Recently, the market has not been very active, so we have taken into account the latest fraud figures. And according to the latest analytical model, this fund could still be self-sufficient in the long run. But of course, we propose the new land first approach first. That means there will be fewer cases covered at the initial stage and fewer payouts under the fund. And we do not have statistics specifically kept for fraud cases involving new land. We include those on old land as well. And by then, when we have more private treaty private treaty grants and land exchange cases, there may be cases requiring payouts from the fund and increased levies. And by then, we'll conduct an analysis again. A short follow-up, please. Yes. According to the Secretary, even when the title certificate is lost, the transaction could still go ahead, but the administration has taken on board our suggestion, and that one will have to go through the taking of oaths, etc., in the event of loss of the title certificate. However, we have not reached the clause-by-clause scrutiny. By then, I will raise my points again. I think that if it is not of absolute necessity, perhaps you should do away with the certificate mechanism. Secretary, I'd also like to clarify that in fact we don't consider this part of the system necessary, but then we have heard stakeholders' views that they would like to have a title certificate ready. And that is why in the future, during conveyancing process, lawyers should be the gatekeeper, and they should verify the title as shown on the title certificate. So concept-wise, we don't think it is necessary to include the title certificate, but we've also taken on board the other stakeholders' wishes, and we just want to emphasize that it's not the case that if the title certificate is lost, the title will be lost. But then, well, right, let me elaborate on this when we come to the clause-by-clause stage. Dr. Wendy Hall. Thank you, Chairman. I thank the professionals for coming here to our meeting and giving us their invaluable views. The first question is for Ms. Chang of Law Society, and the other two questions are for the Secretary. My question for Ms. Lillian Chang is this. For new land, under the new system, when a transaction takes place in the future, will due diligence checks still be required? Because the title certificate can prove indefeasible title. So there is no need to go through the historical deeds. Does it mean that no due diligence checks will be required in the future? Second, when we discussed the matter at the meeting, I think our response is that only applying the new system to new land is too slow. We want to expedite the progress. Now, you mentioned that under the new system, the owner will have, the new owner will have more risks because of the title certificate. However, from the buyer's perspective, there will be more safeguards to ensure the possession of title. So that means that it's a balancing of risks at the end of the day, I want to know whether there are any policies to reduce risks. And is there anything that can help expedite the implementation so that it applies to new land as well as old land? The next question is about what the surveyors said just now. The surveyors referred to controversies surrounding land in the new territories, and they have come up with some very good ideas. For example, the land boundary data should be published, and there should also be some new rules regarding adjudication of matters relating to two adjoining units. Now, these are some very good ideas. Will the administration heed their views and conduct land boundary verification as soon as possible so that the administration is fully prepared for the launch of the new system? Ms. Chang from Law Society. Well, I didn't catch it 100%. I'll try to answer as much as I can. I fully agree that this new system will protect new buyers. For genuine owners, I'd say that they do bear some risks, and that is why we propose to the land registry the mechanism of title certificates. Now, holding the title certificate may not prove conclusively that the holder is a buyer, is a genuine owner, but at least there is another hurdle. That means if the owner is not even able to provide a title certificate, the lawyer in question will then need to conduct due diligence check. The lawyer should be aware, and like you said, perhaps after losing the certificate, the owner can still take an affirmation to verify the ownership, but at the same time, the lawyer may put questions to the owner, such as the payment of management fees and other relevant records. So in terms of due diligence checks, this is something that the lawyers will still need to do. For example, apart from checking the ID cards, in the case of a company, the lawyer in question should also check for change of directorship of the company. If need be, more supporting documents will be required. Does the seller have good title to sell the property? I think it's for lawyers to verify this matter, and the responsibility falls squarely on the shoulder of the lawyer of the selling party. And the lawyer will also need to check whether it has met the time bar and whether the owner is entitled to receive the proceeds of transaction, etc. That is why we've proposed 49 recommendations in the guidelines. Lawyers will have a lot on their plate in the future. Now, for the other point is this: say there is a need to check the historical deeds because of the constructive trust point raised by members. The family members may have all chipped in buying the property, and yet the legal title only registers one name. So there may be 100 such scenarios. Will the beneficial owners be aware of the new system and that they should apply for registration themselves? These are matters that are not relevant to the new land system. So I think time is needed for the government, the public, and the sector to get used to the new system. We have no intention of delaying the implementation, at least not for the sake of protecting jobs for lawyers. I can reassure you.
Thank you. Secretary, may you take the third question? Thank you. Regarding land boundaries, and this issue is commonly seen in the new territories. What I said was an undertaking as well. Outside the scope of this ordinance, we will liaise with the industry to see how we can have a system for individual lots, for developments to take place, for transactions to take place. Professionals may be engaged to verify the land boundaries. When the government needs to resume a piece of land, the land boundaries may have to be checked. We need to review the accuracy of the land boundaries of the land in the new territories one by one. We need to introduce this system having incorporated the views of the professionals with us today. Afterwards, I'll give an account to the Council. Thank you. Next member, Ms. Maggie Chan. Thank you, Chairman. I have two questions. One about the loss of title certificates, and the other is about the assessment of fraud. In relation to the loss of title certificates, just now the Secretary said, or the Registrar said, there would be numbers in relation to the number of replacements. From our perspective of lawyers, it's indeed not very clear. We may think that the certificate with the number 2 is the latest, but then we may not know there is actually a third one. The buyer may not disclose the third title certificate to us. So what will this lead to? This will lead to statutory declaration about the loss of title certificates. The third party and the lawyer needs to have more information. Will there be an affidavit about the loss of title certificates? Will such information be available? Will the owner of the title certificate be requested to take an oath or an affirmation? It's indeed good to have a title certificate, but this will lead to other problems as well. Say, what I talk about, affidavit, the affirmation or an oath. These are potential problems. If one acts in good faith and has exercised due diligence, one doesn't have to shoulder any legal responsibility in relation to any inaccurate information. So does it mean that I have to collect all the information about all the previous owners and their respective title certificates? Does it mean I have to do all these to show that I have already exercised due diligence? I'd like the administration to respond to these questions, and I'd also like to hear from Ms. Lillian Chang. Does it mean I have to check the statutory declaration in relation to any replacement or loss of the title certificates? Well, yes, maybe they can take my question first. Yes, indeed, you have almost used up your time. Ms. Lillian Chang? Well, in my opinion, I don't think we need to check all the title certificates of previous owners. But we need to ask the reasons for loss. Under what circumstances did that person lose the title certificate? In case of any doubt, say if that person isn't given any title certificate, then we'll have to carry out investigation. The title certificate isn't an absolute proof of titles. It serves as a threshold indeed. Well, I hope you can address these 40-odd points. Otherwise, lawyers will have to do a lot of checking, including that of title certificates, whereas in the past we didn't have to do so. Secretary, well, I will first of all respond to the second point. In case of any transaction we refer to the title certificate as well as the register. We check whether the records tally with one another. We don't have to refer to the previous title certificates, otherwise we cannot implement the spirit of this bill. So what if the existing owner or the current owner loses the title certificates? Well, it has to do with information transparency. Every time we approve the replacement of title certificates, how can we allow or how can we enable professionals know that these are the latest replacement documents? We'll definitely disclose such information. When this system is up and running in the future, there will be a lot of interfacing work between the administration and different professionals, say the insurance sector, the banking sector, and the legal sector. We will adopt a perspective of your work. So, if you demand clarifications or clearer explanation about any part of our work, we need to join hands to do so. Last to speak, myself. I thank individuals and deputations who attended the meeting today. You've given us very good opinions. I believe the administration has already heard your views. They will either take note of your views or they will incorporate your views. Thank you. I can see all of you support this bill. We didn't know how to take the first step. Now that we have a plan, we will take the first step soon. The Secretary promised us that the new Land First proposal will be implemented, but there is still a lot of work after that. The Secretary will brief us on the work as well as the issue about land boundaries next year. When we implement the new Land First proposal, we may carry out work in relation to old land in parallel. There is a lot in this plan in the Lands Department, but it isn't updated online. In case of rehousing cases, the Planning Department may see my application, but then the information doesn't tally with that on the website of the Lands Department. The person concerned may be asked to apply for a letter from the Land Department, but then the department may not be willing to issue a letter. Government departments only check the information online. They rely on the information on the internet. So I believe the information online should be updated regularly. There are property transactions or land whose uses are not changed. I want to know if the government has a mechanism in place. This is important as well. Honestly, the New Land First proposal 20 years, and I believe for the older land it will take a longer time. At least we can reduce disputes or make the processes or procedures smoother. For voluntary registration system, or as members mentioned, due diligence or other checks may have to be conducted. When these are done, can they help the government? Say for the New Land First proposal, when it's implemented for 10 years, when there's no other application to deal with the old land, then you cannot follow up on the old land anymore. Ms. Chung. After a transaction, an old land will become a new land. But then you are actually relying on a lawyer to check all the leases. This ordinance is very complicated. A constructive trust is involved if people chip in to buy a piece of land. They may not have the awareness, and they will probably lose the title. There are all too many such cases, and this will render the situation unfair. We need to start the New Land First proposal, and then the public, lawyers, and the administration will be able to accumulate experience before proceeding to the next stage. This is indeed a good policy. But as the industry said, this bill is complicated. In relation to transactions, do you have any transitional plans? Well, I believe what you mentioned concerns land boundaries. Is that right? Thank you. In relation to land boundaries, even if there is no property transaction, if the title owner wants to develop the land, he or she needs to demarcate the land boundaries clearly. Together, we will explore this issue with the industry, not least the pieces of land in the new territories. We need to draw the land boundaries in a systematic manner. We need to deal with this issue in a systematic manner. We did look into such issues. It's been some time, and we may explore this situation now again. After all, we need a pragmatic method, and of course, we don't have resources to solve this issue overnight, but we may explore how to deal with this issue in a systematic manner. 3 more members would like to speak in the second round, but I'd like to leave some time for us to deal with other work. So each member, about 2 minutes. Ms. Doreen Kong, Deputy Chair.
Chairman, I'll try to wrap up in 2 minutes. We have Law Society and Hong Kong IS representatives here. So this new system will be implemented in the first half of 2027. Is that right? My question is, are your members well aware of the new system? Is it that they are well versed? Are they ready? The second is about technology. The new system will rely more heavily on technology than before. I know this is not your responsibility, but just tell me, is it your impression that your members are ready? And like Ms. Chang said, it is not the case that under the new system, many of the steps will be scrapped and that things will be straightforward from now on. Because when it comes to conveyancing, assignment of right is involved, and other matters may stem from the conveyancing process, such as easements, covenants, DMCs. So apart from the title certificate, lawyers will still need to plow through different documents. So when you promote this new system, you also need to level with the public that lawyers are still required to check other important documents. This is something that lawyers must explain to the public. I thank Ms. Chang for explaining the position clearly just now. It's not just about checking the title certificate. Right, Ms. Chang? Thank you, Ms. Kong. We'll try to work with the government as much as possible. In fact, in the past few months, we have drawn up some 40 points. These are points of clarification. We want to address the legal ambiguities. We also have other questions on operational matters. We will be submitting these points to the Electrical and the Land Registry in due course, and we want to support your work as much as possible. About the use of technology, unless we adopt e-lodgement, there shouldn't be a major problem. E-lodgement, even if implemented, will go hand in hand with a physical lodgement, so there should not be a major problem. What about Hong Kong IS? Thank you, Chairman. Let me respond to Ms. Doreen Kong's question. The Hong Kong IS is ready. And from now until implementation in 2027, we will liaise closely with the administration, and we'll also promulgate guidelines for members' reference. On the use of technology, we are very confident. Surveyors do much more than just physical land surveying. We use different technologies. We have drones, we take aerial photos, and we also use technology such as satellites to help make our work more precise. So we will be working with the Lands Department in land surveying exercises. Mr. Jimmy. Now my question is this. Is there any scenario in this bill in which a property transaction can be carried out without the engagement of a lawyer, registrar? The Legal Practitioners Ordinance provides that only lawyers can undertake conveyancing with a fee. So this will continue to be the practice. You're talking about the work for the award. What about self-initiated property transaction? That means I represent myself, no representation at all, such as the transfer of car ownership. If I sell this car to another buyer, then no lawyer will be involved. no reward will be given. It's not covered by the LTO. Under the new system, there is a requirement of verifying the identity, and it can't be done by your own self. So, is there any circumstances under which the the buyers and sellers can complete the assignment without engaging a lawyer? Yes, there could be. No further question. Dr. Wendy Hong. A similar question, a point of clarification. I think many members of the public are listening in. We need to address this confusion. I understand that lawyers will be under a lot of pressure. They will face a lot of risks in the process of adopting the new system. Now, about the title certificate, there could be a chance that the title certificate may be lost. But then the title register comes in only one form. It can't be lost. So just by checking with the title register, we can address the issue of identity. There is no need to, for example, issue title certificates number 1, 2, or 3 about change of directorship. We can just check the entry in the title register to verify the identity of buyers and sellers according to the registrar. If what I'm saying is true, I think you need to publicize the new system better in the future. Who will take this question, Registrar, first? As explained just now, under the Land Title Ordinance, the title register provides indefeasible title. I think this is incorporated in the bill. So ultimately, in order to verify a title, we look at the title register. However, according to stakeholders, they would like to have a physical copy to prove title ownership. And after careful consideration, we do agree with their suggestion. This title certificate can be used as a supporting document. It is a kind of anti-forgery measure. So a lawyer can check this certificate to prove the title of the owner, and by holding this certificate is a form of verification according to the record or the entry in the title register. So it is a useful supporting document. We agree to heed the views of stakeholders. In fact, according to other jurisdictions, in the early stage of implementing the new system, they also have some form of title certificates. And in some countries, perhaps in some certain states or provinces, when the parties to transaction are used to accept the title register as the authority, the title certificate system can be scrapped. But at this stage, we will introduce this mechanism. We will also include anti-forgery features. We'll also enhance publicity. But what about the entries in the title register? They must be genuine. If you can provide 100 proof the good title, then there is no need to have a physical certificate. I understand the rationale of some, but isn't it logic that the entry in the title register should be 100% genuine? How about a further explanation? Well, say if somebody holds the ID card, then just by looking at the name of the ID card, you can verify the identity. But then you may still wish to check the title certificate as well as an anti-forgery feature. Deputy Chair, just very quickly, a follow-up question. It's a question for Ms. Zhang. We have case authorities in Hong Kong that have a bearing on a case on land law in Hong Kong. Now, have you talked to the government about the correlations of the case laws in the new system? We're going to make a submission to the LegCo and the Land Registry in which we will raise certain issues. We want to enhance clarity. Thank you for coming. I think we have completed this item, that is inviting deputations to give views on the Titles and Land Miscellaneous Amendments Bill 2025. You may be excused, and after you've left the room, we'll continue with meeting with the administration. The administration already provided a response paper to the issues raised at the last meeting of the 8th of April. So I will invite the administration to go through their response first and see if there are follow-up questions. And depending on the time, we may start the clause-by-clause scrutiny. Registrar. About the items arising from the discussion at the previous meeting, we've provided a written response. The first point relates to details about the assumptions and factors, including the respective ratios, transactions of the land titles indemnity fund. And according to our reply, we conducted this assessment in 2022. We considered, for example, the historical data, the amount of money involved. We have not kept statistics regarding the details of different types of transactions, and we have not conducted the analysis according to the different types of properties. We also consider the transaction volume and the average amount of transaction subject to different points in the economic cycle. We've already provided a response. The fourth point relates to the number of fraud cases and also the amount of losses. This is how the model is run. We put in different data in order to compute the cap of the indemnity fund and the levy rate. As explained, the consultant has taken a lot of time to go through the data I mentioned, assuming that there is one case each between the 7th and the 9th year, and then 4 cases of claim between the 14th and the 16th year. In a 20-year model, then the number of fraud cases computed will be on the high side. And we also consider the owner's affordability, public acceptance. According to the consultant, a high cap may impact on the long-term sustainability of the fund, and that is why the levy rate is now proposed to be set at 0.014% and the cap $50 million. As explained, the $50 million cap will capture 99% or over 99% of all registered transactions. As for the 0.014% levy rate, at most, a buyer will only need to pay $7,000 In other words, for a $1 million transaction, for the buyer will need to pay $140 in levy. We find this amount acceptable. In fact, we ran the assessment having regard to the latest market situation and other data. We made adjustments to two assumptions. First, we assume that the new system will only cover new land without auto conversion. We reran the model. The consultant's earlier assessment involves auto conversion at the lapse of 9 years, and we've now had a new thinking. So we've taken this out. We've also put in another assumption that is no fraud case in the first 10 years because of the few cases envisaged in the first stage of new land, and we've also made use of the fraud data that we have. So taking this assumption, by the 10th year, the balance of the fund will stand at $143 billion, and the balance at the 20th year will be $206 billion. So that means there will still be surplus in the balance. However, we should note that if there is auto conversion, there will be a higher levy. The balance will be higher because of the levy. So at this moment, if we take a conversion approach that is risk controlled, then without substantially adjusting the levy rate, we will be able to process claims relating to clean cases after conversion.
We mentioned implementing measures in phases. And in these cases, there are fewer title issues. They account for some 20% of all the cases in the land registry. And we will draw reference from this figure, and we will finish the conversion of such lands first. And whether we can make it mandatory or voluntary when it comes to conversion, we will further liaise with stakeholders. For registration figures in the land registry, there is no breakdown according to different type of properties, so there's a lack of figures for the consultant to conduct analyses. In relation to higher value properties, the maximum indemnity amount is $50 million. And there are some 700 cases. Members talked about setting a higher levy rate or to raise the indemnity cap. The consultant already looked into the situation. There weren't much fraud cases in relation to commercial buildings. The number was on the low side as well. So when we implement the New Land First proposal, we want to make the indemnity system simpler. That's exactly why we have a uniform rate. In the future, when we accumulate certain experience and figures, we may conduct an evaluation and assessment in due course. See if the land registrar needs to amend the record on the land register, will the relevant person receive any notification? We have already drawn reference from members' opinion. We will use the existing service, that is Property Alert. The applicants of Property Alert will be notified by way of emails. If they wish, they may receive SMS notification as well. In relation to D, when the registrar exercise an order, you may find information in paragraphs 12 all the way to 17. First of all, when we receive such news, we will conduct internal investigation. We will inspect the relevant documents and liaise with the informant. We will also seek legal advice. We will suggest the relevant person to make a police report as soon as possible. We will then suspend the registration of the relevant property and liaise with the police. We will assess the overall situation and discuss with the police force to consider whether there is sufficient evidence to prove fraudulent transaction. Evidence includes say the person has already passed away before the signing of the document, or someone is impersonating that person or the other person to sign the document. In the case of any he said, she said events, we need to see real evidence. Under the ordinance, the registrar will draw reference from some facts to conduct investigations. See, in accordance with Section 8(2), the registrar may require the relevant person to provide information or explanation. When the lawyer is making an application for registration, the lawyer has signed a certificate. The lawyer may conduct due diligence, and we may ask the lawyer to provide more information. Property owners will have to provide the title of certificates at the time of conveyancing. Then we may verify the authenticity of the title certificates. Then we may determine whether there is any fraud involved. The registrar will then make a decision based on the information provided to the registrar as well as that provided to the police force. We will also see what impacts will be exerted on persons who have interests. When we issue an order, we will send emails or written documents to the property owner as well as other people who have interests. The relevant order will also be shown on the title register. So for people who inspect the register, they will be informed of such an order. Property owner or other persons who have interest may, by way of written submission, apply to the land register to the land registrar to apply for a ratification or a deletion order. We want to let the public know what happens during the process regarding our role with the police force. There is not much difference. The police conducts criminal investigation, and we make sure that we will carry out investigation based on the objective facts, and we also conduct follow-up afterwards. At the last meeting, members asked about charging any indemnity levy. Say for probate, in accordance with the bill, in case fraud is involved, leading to the loss of property owners, that person will receive indemnity. If a transaction is transferred from one person to another person by way of law, the ownership of real estate will be vested by the deceased to the other person. That is done by way of law, and that is not part of property conveyancing. In this case, a levy will not be charged. However, if the ownership of the title of the probate is vested from the administrator to the beneficiary, then there will be levy. That is similar to intra-group transfer, because that concerns a change in the ownership. Thank you, Registrar, for your very detailed explanation. I will first of all extend the meeting by 15 minutes. 2 members will speak. Any more members would like to speak? If no, after these 2 members speak, I will wrap up policy discussion, and I will start the clause-by-clause scrutiny at the next meeting. Let's start with Mr. Louis Long. Thank you, Chairman. About the amount of the indemnity, according to our policy, there's a cap of $50 million. According to the paper provided by the administration in paragraph 7, this amount already covers 99% of all the property transactions in Hong Kong. But in paragraph 7, the last sentence is that if we introduce a tiered levy in relation to the indemnity for higher value property transactions, the management of the indemnity fund will become more complicated, and the administrative costs will also rise as a result. So, when I read this sentence, what I understood was that this is actually possible. We can do so. But then, the management of the fund will become more complicated, and the administrative costs will also rise. Is that correct? We take into account the cost-benefit analysis. So I'd like to ask the administration can you let the public know for higher value property transactions if the buyers concerned are willing to pay a higher indemnity rate, how much exactly do they need to pay? Will the complexity of the fund management really make it impossible for us to introduce a tiered levy system?
容許我
Secretary. Now, speaking in plain language, is it really not feasible? We have different types of property transactions. Is it possible to introduce different tiers of levy? The answer technically is yes. However, we do not want to make it complicated and hence difficult for people to understand, because we pride ourselves on having a low and simple tax regime in Hong Kong. So since we're introducing a levy under the new system, if we make it complicated by introducing a tiered levy structure, from policy's point of view, technically this is not impossible, but I believe that there are more cons than pros because of the more time taken for the details. We have not conducted a detailed analysis on the different tiers to be proposed, especially for higher amounts of transactions and the implications. I'm afraid we have not conducted this analysis. P.S. I want to supplement. I think we should also read paragraph 8 together. The Secretary already explained that technically it is feasible to introduce a tiered levy structure, but is it really necessary to have a tiered structure? According to paragraph 8, we have not recorded a lot of fraud cases involving non-domestic properties. So that's one way of answering the question. The other point is that we keep close liaison with the police on the modus operandi and the latest trend of fraud. The police has given us their take on what the cap should be under the indemnity fund. If there is no cap, according to the police, this may result in a backlash, and that will also spark a surge in the number of fraud cases. So you can take a tiered risk-based approach and provide a high cap for higher value transactions, but in the end of the day, the operation of the fund will be affected in general. That means with fraud getting more prevalent, a higher levy will have to be charged across the board, affecting small owners. And that is why our policy consideration is that a cap of $50 million should be imposed. Next, Mr. Tony Chair. I thank the administration for giving us a detailed reply. I raised 2 points. First, on the indemnity fund, and second, on the registrar's efforts in combating fraud, and this is crucial as the land registrar will be the gatekeeper. As I understand, the amount of payout will be capped at $7,000 under the indemnity fund, and I fully appreciate the difficulty in providing different mechanisms for different types of transactions. It will complicate the matter. And of course, if, as you said, it's 1/8 of the property value, then what should the levy rate be? It could be quite substantial. It is unfair for transactions involving small amounts to be subject to a higher levy in order to subsidize the other high amount transactions. So perhaps you should review the situation of the market later on. My other question is this. You've made reference to other jurisdictions with similar arrangements. Have you also looked into the operation of similar indemnity funds, whether they've been used? Secretary, I'll give the floor to the registrar to take this question. We've tapped into the practices of other countries in terms of the scope of compensation, time frame, levy rates. Different jurisdictions adopt different approaches. In Singapore, for example, the indemnity fund doesn't cover fraud cases. It only covers human errors. In other jurisdictions, a fixed levy may be charged not on properties transferred, but on all properties in general. For some other jurisdictions, they may set aside a fund from the land registry department or from the public office. 20 years ago, when we enacted the Land Titles Ordinance, we advocated the users pay principle, and in fact the practices in other jurisdictions are quite different. In the UK, there are the property fraud cases are prevalent, but there aren't many involving residential properties. Having regard to the experience in other places, we also looked at the credit referencing consultancy study conducted a decade ago, and on this basis, we devised the proposed levy rates. As we discussed this proposal with other jurisdictions, I have a feeling that we're all concerned about fraud. In fact, they've set up a working group to share experience on fraud prevention measures. Well, Land Registrar just mentioned the property frauds in the UK being quite prevalent, but the amounts involved are not huge. We're concerned. I'm also happy to learn that a working group has been set up. I hope that the existing problems of property fraud can be eradicated in the under the new system. Please note this comment. Let's see if we have questions from other members. If not, I think that the Bills Committee has completed a discussion on the merits of the bill and policy matters. For the completeness of the meeting, since we do not have much time left, we will start the clause-by-clause scrutiny next time. That means we will move on to the clause-by-clause scrutiny at the next meeting. If there is nothing under AOB, the date and time of the next meeting are as follows: 4:30 on the 19th of May, 4:30 to 6:30. Meeting's adjourned. Thank you.